Before we begin, a quick and important disclaimer. The following content is provided strictly for educational and entertainment purposes. This video does not constitute legal, financial, or professional advice. The history, statistics, and case studies discussed are intended to provide a historical and analytical overview of the legal profession and do not reflect the specific legal requirements of any individual jurisdiction. Laws regarding domestic relations vary significantly by state and are subject to change. Viewers are strongly encouraged to conduct their own due diligence and consult with a licensed professional attorney in their specific area before making any legal or financial decisions. There is a staggering statistic that has defined the American social fabric for over half a century. Nearly half of all marriages in the United States are projected to end in dissolution. But behind that number lies a massive multi-billion-dollar legal machinery that few truly understand. We often look at divorce as a personal failure or a social trend, but statistically, it is one of the most consistent economic engines in the American legal system. For decades, the divorce lawyer has been cast as the villain in the American story, a predatory figure waiting for love to fail. Yet, if we look at the historical data, a different picture emerges. The rise of the divorce lawyer was not the cause of the breakdown of the American family. It was a legislative and economic response to a society that was already changing. In the next few minutes, we are going to pull back the curtain on the evolution of this profession. From the days when you had to prove physical cruelty or adultery just to escape a toxic household, to the modern era of high-stakes asset division, we are going to explore how a niche, often shunned area of the law became a dominant force that dictates the flow of billions of dollars in personal wealth every year. If you have ever wondered why the legal process of ending a marriage is so complex, expensive, and statistically inevitable for many, you need to see how we got here. This is a masterclass in the history of the American divorce lawyer, and today we are solving the mystery of the legal system you hope you never have to use, but which historical trends suggest you likely will. By understanding the statistical shifts from the mid-20th century to today, you will gain a clear-eyed perspective on the potential outcomes of the modern legal landscape. This isn't just a history lesson. It is a roadmap of the American legal evolution that explains exactly why the system functions the way it does in 2026. To understand the modern divorce lawyer, we must first look at the era of fault. Before the late 1960s, the legal concept of a no-fault divorce essentially did not exist in the United States. This created a legal environment that was statistically fascinating and ethically murky. In the 1940s and 50s, if a couple wanted to separate, they couldn't simply cite irreconcilable differences. One party had to be the innocent spouse, and the other had to be the guilty party. The grounds were strict: adultery, extreme cruelty, or willful desertion. From a statistical standpoint, this led to a massive surge in what historians call collusive divorces. Because the law required a villain, lawyers were often tasked with manufacturing evidence. In New York, for instance, there was a well-documented industry of professional correspondents, women who were paid to be photographed in hotel rooms with husbands to provide the necessary proof of adultery for the court. This era birthed the first iteration of the specialized divorce lawyer, but they weren't the high-powered figures we see today. They were often viewed with suspicion by the rest of the legal community. Statistically, the volume of divorces was lower, but the intensity of each case was significantly higher. Because a spouse had to prove fault, to receive alimony or a favorable property division, the lawyer's role was more like a private investigator than a legal mediator. Historical trends show that during this period, the cost of a divorce was prohibitively high for the working class, not necessarily because of high hourly rates, but because of the sheer amount of investigative work required to secure a judgment. The shift began in the post-World War II era. As the baby boom began, so did a subtle but measurable increase in marital dissolution. In 1946, there was a massive spike in divorces, approximately 610,000, as returning veterans and the women who had entered the workforce during the war found they could no longer reconcile their changed lives. This was the first major statistical bubble in the divorce industry. However, the legal profession was still unorganized. It wasn't until 1962 that the American Academy of Matrimonial Lawyers was founded. This marks a critical turning point in our deep dive. The founding of this organization was a signal that matrimonial law was no longer a side hustle for general practitioners. It was becoming a specialized science. The real seismic shift, however, occurred in 1969, when then-Governor Ronald Reagan signed the California Family Law Act. He inadvertently launched the modern era of the divorce lawyer. This was the first no-fault divorce law in the nation. Statistically, the impact was immediate and profound. Within a decade, nearly every state followed suit. The open loop here is fascinating. Why did making divorce easier legally actually make the profession of divorce law more lucrative and complex? You would think that removing the need for investigators and fault would simplify things. Instead, it shifted the battleground from morality to mathematics. With the removal of fault, the lawyer's role transformed overnight. Instead of searching for lipstick on a collar, they began searching for hidden offshore accounts, undervalued business interests, and complex retirement portfolios. The statistical rise in the number of practicing family law attorneys correlates almost perfectly with the increase in American household wealth and the complexity of the tax code. By the 1980s, the celebrity divorce lawyer became a staple of American media. Case studies from this era show that as women entered the workforce in record numbers and marital assets became more multifaceted, the legal requirements for a fair distribution became a high-level accounting exercise. We must also look at the demographic data of the profession itself. In the 1970s, the legal field was overwhelmingly male. As the divorce rate climbed toward its historical peak in 1980, reaching approximately 5.3 per 1,000 people, the demand for legal representation created a new pathway for women entering the legal profession. Family law became one of the first sectors where female attorneys could build massive, influential practices. This changed the negotiation dynamics in the courtroom and at the mediation table. As we continue this deep dive, we have to address the golden age of the divorce lawyer, which occurred between 1980 and 2000. During this window, the legal industry professionalized the contested divorce. This is where the statistics get truly eye-opening. The average cost of a contested divorce in the U.S. began to outpace inflation significantly. Lawyers were no longer just filing paperwork. They were managing entire teams of forensic accountants, child psychologists, and vocational experts. This deep dive into the history shows us that the divorce lawyer became the project manager of a family's dissolution. But why does this history matter to you today? Because the precedents set during the no-fault revolution and the asset war era of the 80s and 90s are the exact rules that govern your bank account and your parental rights in 2026. The evolution of the lawyer from a moral arbiter to a financial strategist is the reason why modern family law is less about who did what and more about who keeps what. By analyzing these historical trends, we can see that the legal profession didn't just grow. It adapted to the increasing complexity of American life. As we move forward in this series, we will examine the specific case studies that changed the laws of alimony, the statistical impact of prenuptial agreements on divorce rates, and how the digital age has once again transformed the evidence that lawyers use in court. But it all starts here, with the understanding that the U.S. divorce lawyer is a mirror of American society's shifting values on money, family, and the pursuit of individual happiness. The history of this profession is the history of the American family itself. Messy, expensive, and constantly evolving. This is part 1 of our 10-part masterclass, and we are just scratching the surface of the data that defines the Great American Breakup. To understand the explosive growth of the divorce legal industry, we have to look closely at the decade where everything changed. The 1980s. This was the era of the high-stakes financial war. While the 1970s had established the legal framework for no-fault divorce, the 1980s introduced a level of economic complexity that transformed the family law practitioner into a high-level financial strategist. Historical trends during this period show that as American household wealth shifted from tangible assets like land and jewelry to intangible assets like pensions, stock options, and professional licenses, the legal requirements for representation skyrocketed. Imagine if it is 1986. You are an executive named David living in a suburb of Chicago. You and your spouse, Sarah, have decided to end your 15-year marriage. In 1956, your father's divorce would have been a matter of proving a moral failing. But in 1986, your lawyer is not looking for a private investigator to hide in the bushes. They are looking for a forensic accountant. You have a 401k, which was a relatively new vehicle at the time, a vested pension, and stock options that won't mature for another 5 years. This scenario represents the exact moment when the American divorce lawyer became a necessary gatekeeper to personal solvency. Statistically, the 1980s saw the emergence of what we now call the boutique family law firm. Before this, divorce was often handled by general practitioners who also wrote wills and handled real estate closings. But as the divorce rate hit its historical peak of 5.3 per 1,000 people in 1981, The sheer volume of cases created a market for specialists. Data from the American Bar Association shows a significant uptick in the number of attorneys identifying exclusively as matrimonial or family law specialists during this window. These lawyers were the first to leverage the billable hour model in a way that mirrored corporate law firms, leading to a massive increase in the average cost of litigation. One of the most critical case studies from this era that every modern lawyer still studies is O'Brien v. O'Brien, decided by the New York Court of Appeals in 1985. This case is a perfect example of the deep dive into asset valuation that defines the profession. In this case, the court ruled that a medical license acquired during the marriage was marital property subject to equitable distribution. This was a statistical and legal bombshell. It meant that a lawyer's job was no longer just dividing the house and the car. It was now about calculating the net present value of a lifetime of future earnings. Lawyers had to become experts in actuarial science and economic forecasting. They had to argue over the statistical probability of a doctor's career path and the inflation-adjusted value of a degree. This case study alone added layers of complexity and cost to thousands of divorces across the country, as lawyers now had to hire expert witnesses to testify on the value of human capital. By the early 1990s, the profession entered a new phase characterized by the professionalization of conflict. Historical trends indicate that as the legal industry grew, the methods of discovery became more aggressive. This is where we see the rise of the request for production of documents reaching hundreds of pages. Lawyers began to use the legal process itself as a tactical tool. For a character like James, a small business owner in 1994, a divorce meant that every single receipt, ledger, and tax return for the last decade was now subject to legal scrutiny. The divorce lawyer was now a data analyst. They were looking for something called double dipping. The idea of counting a business's value as both an asset to be divided and a source of income for alimony. The economic impact of this specialization cannot be overstated. Case studies from the mid-1990s show that in high-net-worth cases, the cost of expert witnesses, accountants, psychologists, and appraisers often rivaled the cost of the attorneys themselves. This created a statistical divide in the American justice system. Historical data suggests that while the wealthy could afford the forensic deep dive necessary to protect their interests, the middle and lower classes were often left with a standard, one-size-fits-all division of assets that didn't account for the nuances of their financial lives. This led to the potential outcome of a widening wealth gap post-divorce, a trend that researchers have tracked for decades. Furthermore, we must examine the shift in how alimony or spousal support was calculated. Statistically, the 1990s saw a sharp decline in permanent alimony. As more women entered the workforce, the historical trend moved toward what lawyers call rehabilitative alimony. This was intended to be a short-term financial bridge. Lawyers had to adapt their arguments from a needs-based approach to a contribution-based approach. They started using vocational experts to prove that a stay-at-home spouse had the statistical potential to earn a specific salary if they re-entered the job market. This step-by-step deconstruction of a spouse's potential future became a standard part of the divorce lawyer's toolkit. As we move toward the year 2000, the digital revolution began to leave its mark on the profession. Imagine if it is 1999 and you are a lawyer in Los Angeles. You are no longer just looking at paper bank statements. You are starting to deal with the first wave of email evidence. This was the precursor to the massive e-discovery industry we see today. The divorce lawyer's role expanded again to include digital forensics. Statistical evidence from the early 2000s shows that electronic communication became a factor in over 60% of divorce cases almost overnight. This added yet another layer of technical expertise required by the legal team. In our current year of 2026, we look back at these decades as the foundational era of the modern legal machine. The divorce lawyer evolved from a social pariah in the 1950s to a financial architect in the 1980s and a digital investigator by the turn of the century. This evolution was driven entirely by the changing nature of American wealth. We are now seeing the potential outcomes of this long history in the way modern courts handle cryptocurrency, virtual real estate, and even the valuation of social media influence. Every step-by-step advancement in how we value a business or a career path was fought for in the courtrooms of the 80s and 90s. The data shows us that as society becomes more complex, the legal system must become more invasive to remain equitable. But this invasiveness comes with a staggering price tag. The statistical reality is that the cost of a divorce has risen at a rate that far exceeds the standard consumer price index. We are looking at a system where the entry-level price for a contested trial can exceed the annual median income of an American household. We have explored how the lawyer became a financial expert and a digital sleuth, but there is one area of the law that remains the most volatile, the most expensive, and the most statistically unpredictable: the battle for the children. While money can be counted and businesses can be appraised, how do you put a statistical value on a parent's time? In the next part of this deep dive, we are going to look at the dark history of custody battles, the rise of the guardian ad litem, and the shocking data behind how the legal system decides who gets to raise the next generation of Americans. Why did the tender years doctrine disappear, and what replaced it? You won't want to miss the statistical shift that changed the American family dynamic forever. To understand where we are in 2026, we have to look back at the radical transformation of how the American legal system views children. For nearly a century, the U.S. divorce lawyer operated under a legal framework that was statistically biased and functionally rigid. This was the era of the tender years doctrine. This judicial presumption suggested that during a child's tender years, typically defined as under the age of 7, the mother was biologically and emotionally better suited for custody. Statistically, this led to an era where mothers were awarded sole physical custody in over 90% of cases. For a lawyer in the 1950s or 60s, a custody battle was rarely a battle at all. It was a foregone conclusion unless the mother was proven to be morally unfit. Imagine if it is 1965, and you are a father named Robert in Ohio. You are a hardworking provider who deeply loves your children, but the historical trends of the time are stacked against you. To win custody, your lawyer would have to prove that your wife was not just a bad spouse but a dangerous or negligent parent. The bar was incredibly high, involving testimonies about alcoholism or extreme abandonment. Consequently, most divorce lawyers advise fathers to settle for every other weekend, creating the statistical phenomenon of the visitor father that dominated the American landscape for decades. However, as we moved into the 1970s, the legal philosophy shifted toward the best interests of the child standard. This was codified in the 1970 Uniform Marriage and Divorce Act, which instructed judges to look at the child's needs rather than gender-based presumptions. But here is the statistical catch. While the law became gender-neutral on paper, the practice remained largely the same for years. Lawyers had to navigate a system where judges still held deep-seated biases. This created a new specialized industry within family law, the custody evaluator. In the 1980s, the role of the divorce lawyer expanded to become the coordinator of a multidisciplinary team. If you were a lawyer representing a client in a high-conflict custody case, you were no longer just arguing statutes. You were hiring forensic psychologists to conduct MMPI-2 personality tests on the parents. You were coordinating home studies where social workers would inspect the cleanliness of a bedroom or the contents of a refrigerator. This shift turned child custody into one of the most expensive and time-consuming segments of the legal industry. Data from the late 1990s indicates that a fully litigated custody trial could easily require over 200 hours of legal work, involving thousands of pages of psychological reports. Consider the landmark case of Palmore versus Sidoti in 1984. While this case specifically addressed race, it signaled the Supreme Court's insistence that custody decisions be based on the actual well-being of the child, rather than societal prejudices. This forced divorce lawyers to become data-driven. They began using school records, pediatric logs, and witness testimony from teachers to build a statistical case for which parent was the primary caretaker. The term primary caretaker became the new legal gold standard. Lawyers would meticulously document who took the child to the dentist, who helped with homework, and who prepared the meals. This step-by-step documentation was the only way to overcome the lingering remnants of the tender years doctrine. The financial cost of these battles reached a breaking point in the early 2000s. Historical trends show that as the complexity of custody litigation increased, so did the rise of the guardian ad litem, or JL. A GAL is an attorney appointed by the court specifically to represent the interests of the children. In a contested case, this meant that instead of 2 lawyers there were now 3, all billing by the hour. For a middle-class family in 2005, a custody battle could deplete a college fund or a home's equity in a matter of months. Statistical analysis from this period suggests that the threat of a high-cost custody battle was often used as a tactical lever in financial negotiations, a practice that many modern ethics boards have worked hard to curb. By 2015, we began to see the rise of the 50-50 presumption movement. States like Kentucky and later Florida began passing laws that started with the statistical assumption that equal time with both parents is in the best interest of the child. This was a revolutionary shift for the divorce lawyer. No longer was the goal to win or lose a child, the goal shifted toward logistics. Imagine if it is 2026 and you are a character named Mark in Miami. You are going through a divorce, and because of the 2023 legislative shifts, the starting point is equal time. Your lawyer's job is no longer to prove your ex-spouse is a bad parent, but to design a highly complex, data-backed parenting schedule that accounts for your work commute, the children's extracurricular activities, and the geographic distance between homes. In this modern 2026 landscape, technology has become the lead witness. Lawyers now rely on apps like Our Family Wizard or Talking Parents. Every text, every calendar update, and every reimbursement request is logged and admissible in court. Statistically, this has led to a decrease in he said, she said testimony and an increase in digital evidence. A lawyer today might present a spreadsheet showing that one parent was late for 14% of exchanges over a 6-month period. This is the new frontier of custody litigation, the statistical analysis of parenting behavior. The potential outcomes of this shift are profound. We are seeing a stabilization in the time fathers spend with their children post-divorce, which historical data suggests leads to better long-term emotional outcomes for the children. However, the legal machinery required to manage these 50-50 splits is more complex than ever. If the parents cannot agree on a school or a medical treatment, the lawyers are back in court, arguing over tie-breaking authority. The divorce lawyer has evolved from a litigator of fault to a manager of co-parenting. But as we have seen the cost of custody rise, a new movement has emerged that threatens the traditional billable hour model of the family law firm. While lawyers were busy perfecting the art of the custody trial, a new wave of alternative dispute resolution was quietly taking over the industry. Mediation, collaborative law, and even AI-driven settlement tools are changing the math of how marriages end. This brings us to a critical question. As the legal process becomes too expensive for the average American, is the era of the high-powered divorce attorney coming to an end? Or is it just evolving into something even more pervasive? In the next part of this deep dive, we are going to look at the rise of the mediation industrial complex. We will examine the data behind why 95% of cases now settle before trial, and how lawyers have adapted their business models to survive in a world where judges are increasingly forcing couples to stay out of the courtroom. We will also explore the secret history of the divorce mill, and how some jurisdictions turned the dissolution of marriage into a high-volume, low-cost assembly line. You won't want to miss the shocking statistics on how much money is saved or lost when you take the judge out of the equation. The shift from the aggressive litigation of the 1980s to the mediation-heavy landscape we see in 2026 did not happen by accident. It was a calculated response to a judicial system that was physically and financially breaking under the weight of its own caseload. To understand the rise of the mediation industrial complex, we have to look at the statistical clogging of the American court system that began in the late 1980s. By 1990, family law cases made up nearly 35% of all civil filings in many state courts. Judges were overwhelmed, dockets were backed up for 18 months, and the potential outcomes for families were becoming increasingly disastrous due to the sheer delay in justice. This environment birthed the mandatory mediation movement. Imagine if it is 1992, and you are a lawyer in Florida. Your state has just become a pioneer by implementing a comprehensive mediation statute. Suddenly, the historical trends of walking into a courtroom and letting a judge decide your client's fate are being replaced by a requirement to sit in a conference room with a neutral third party. For the divorce lawyer, this was a moment of existential crisis. If cases settle in a conference room in 4 hours, what happens to the 200 billable hours previously generated by a trial? The data shows that the legal profession adapted with remarkable speed. Instead of fighting mediation, lawyers colonized it. They rebranded themselves as lawyer mediators or collaborative law specialists. Historical data from the mid-1990s indicates that the number of attorneys seeking mediation certification increased by over 400% in some jurisdictions. This created a new economic model. While the individual case might generate fewer hours, the volume of cases a lawyer could handle increased. The divorce mill began to evolve from a low-rent operation into a high-efficiency, high-volume professional service. Let's look at the math of mediation through a modern lens. Imagine a character named Alex in current year 2026. Alex and his spouse own a mid-sized home in Austin and have 2 children. In a traditional 1980s-style litigated divorce, each side would retain a boutique firm with a $10,000 retainer. Statistical trends suggest that such a case, if it went to a full 3-day trial, would cost the family between $40,000 and $60,000 in combined legal fees. In 2026, Alex's lawyer suggests a mediation-first approach. The mediator charges $400 an hour, split between the parties. Data from 2024 and 2025 shows that 75 to 85% of mediation-eligible cases reach a full agreement within 2 sessions. For Alex, the potential outcome is a total legal bill of under $8,000. This sounds like a win for the public, but the historical deep dive reveals a darker side to this efficiency. Case studies from the early 2000s, particularly in states like California and New York, began to highlight the power imbalance inherent in the mediation room. When a high-earning spouse with a sophisticated understanding of the family finances sits across from a spouse who has been out of the workforce, the neutral mediator is technically forbidden from giving legal advice. This is where the divorce lawyer's role became even more specialized. They transitioned into the role of the shadow advisor. They aren't the ones talking in the mediation, but they are the ones analyzing the spreadsheets in the background, ensuring that the 50-50 split is actually 50-50 and not a statistically skewed version of the truth. Step by step, the mediation process became its own bureaucracy. First, there is the pre-mediation discovery, where lawyers exchange sworn financial statements. Then, the selection of the mediator, which is often a strategic battle in itself. Historical trends show that lawyers often keep books on mediators, tracking their statistical likelihood of favoring the husband or the wife in alimony disputes. By the time the parties actually sit down to talk, thousands of dollars have already been spent preparing the battlefield. We also have to address the rise of the divorce mill, the assembly line of the legal world. In the early 2010s, as the internet democratized access to legal forms, the divorce lawyer faced a new threat: the pro-se litigant. These are individuals who represent themselves using automated document preparation services. Statistically, the number of self-represented litigants in family court climbed to over 70% in some counties by 2018. This was a direct result of the legal profession's historical failure to remain affordable for the average American household. The lawyer's response to this was the creation of unbundled legal services. This is a crucial concept in our masterclass. Instead of hiring a lawyer to handle the whole case, you hire them for a specific task, like reviewing a settlement agreement or drafting a complex pension order. This allowed the legal profession to capture the revenue from the pro-se movement without the liability of a full-scale representation. Data from 2023 shows that unbundled services now account for nearly 20% of the revenue for many suburban family law firms. However, the assembly line approach has led to a statistical surge in post-judgment litigation. When people use a $199 online divorce kit or a high-volume, low-cost mill, they often miss the technical details that matter 5 years down the road. Historical trends indicate that cases settled through high-volume mills are 30% more likely to return to court within 3 years due to ambiguous language regarding child support adjustments or the sale of the family home. The divorce lawyer of 2026 is often spending more time fixing the mistakes of the 2021 assembly line than they are litigating new cases. Consider the case study of a 2022 filing in Georgia, where a couple used an automated platform to divide a 401k. They didn't realize that the legal language required a specific document called a Qualified Domestic Relations Order, or QDRO. Because their lawyer-less agreement was silent on who was responsible for the QDRO, the funds were never actually moved. When the husband retired 3 years later, the wife discovered she had no legal access to the money. This led to a 2-year legal battle that cost 3 times what a proper lawyer-led mediation would have cost initially. This is the paradox of the divorce mill. Saving money on the front end often leads to a statistical nightmare on the back end. The profession has also had to grapple with the emotional data of dissolution. In the 2020s, the concept of the trauma-informed lawyer emerged. Historical trends show that as the legal system became more efficient, it became more cold. Lawyers realized that a client who feels heard is a client who settles. This led to the integration of divorce coaches into the legal team. Now, in 2026, it is common for a top-tier firm to have an in-house therapist or coach whose job is to manage the client's emotional volatility, so the lawyer can focus on the statistical division of assets. This is the ultimate evolution of the profession. A total service model that treats a divorce not just as a legal event, but as a life transition. We have explored the shift from the courtroom to the conference room and the rise of the assembly line legal service. But as we look at the state of the industry today, a new and far more powerful force is beginning to take over. We are moving beyond the mediator and the mill into the era of the algorithm. As we enter the next part of this deep dive, We are going to look at the terrifying and fascinating rise of AI in family law. How is machine learning being used to predict how a judge will rule on a custody dispute? What happens to the billable hour when a computer can analyze 10 years of bank statements in 6 seconds? And most importantly, is the era of the human divorce lawyer finally coming to an end? You need to see the data on how silicon is replacing the suit in the modern American breakup. The integration of artificial intelligence into the American legal system was not a sudden takeover, but a gradual statistical creep that reached a fever pitch in the early 2020s. To understand where the divorce lawyer stands in 2026, we have to look at the massive data transition that occurred between 2021 and 2024. During this window, the legal industry saw a 300% increase in capital investment toward legal tech startups focused specifically on family law automation. The historical trends show that the most labor-intensive part of any divorce, the process known as discovery, was the first to be disrupted by silicon. Imagine if it is 2026 and you are a character named Michael, a software engineer in San Francisco. You are going through a high-asset divorce. In 2010, your lawyer would have assigned a junior associate billing at $300 an hour to spend 3 weeks manually reviewing 5 years of your bank statements, credit card receipts, and tax filings. They would be looking for something called dissipation of marital assets, evidence that one spouse spent joint money on non-marital expenses like luxury gifts or secret travel. Statistically, this manual review was prone to a 20% error rate and could cost a client upwards of $15,000 just for the labor. In our current year of 2026, Michael's lawyer uses an AI-driven forensic engine. This software performs a step-by-step audit of 10,000 pages of financial data in approximately 90 seconds. It doesn't just look for large withdrawals. It uses pattern recognition to identify statistical anomalies. For example, it might flag that every Tuesday for 3 years, there was a $65 charge at a specific boutique cafe that neither spouse frequented. By cross-referencing this with geolocation data from social media or shared digital calendars, the AI can build a timeline of hidden activity that a human eye would almost certainly miss. The potential outcome here is a level of financial transparency that was historically impossible, and it has fundamentally changed the leverage attorneys have during settlement negotiations. But the data-driven evolution goes much deeper than just accounting. One of the most controversial shifts in the profession is the rise of predictive judicial analytics. Historical trends from the last 5 years show that law firms are increasingly subscribing to databases that track every single ruling made by specific judges. Imagine a lawyer named Sarah in 2026 who is preparing for a custody hearing in front of Judge Thompson in Philadelphia. Before Sarah even files her motion, she runs Judge Thompson's entire 15-year career through an analytical model. The data reveals that Judge Thompson has a statistical bias toward awarding the primary residence to the parent who lives within the existing school district 82% of the time. However, the data also shows that if the other parent can prove they have a flexible work-from-home schedule, that percentage drops to 55%. Sarah doesn't just guess what the judge wants to hear. She uses this statistical roadmap to tailor her argument. She presents a step-by-step breakdown of her client's remote work hours, backed by digital productivity logs, because the data tells her that this is the specific variable that moves the needle for this specific judge. This shift has turned the art of persuasion into a science of probability. We also have to examine the statistical impact of the blockchain on the modern divorce lawyer. In the late 2010s, cryptocurrency was a niche issue in family law. By 2026, it is the primary theater of war. Historical data indicates that approximately 15% of contested divorces now involve some form of digital asset, from Bitcoin and Ethereum to more complex decentralized finance tokens and virtual real estate. The problem for the 20th century lawyer was that these assets are designed to be pseudonymous. Case studies from 2024 highlight the emergence of the crypto divorce specialist. These are lawyers who work alongside on-chain forensic analysts. The step-by-step process of asset recovery now involves tracking peels and mixers across the blockchain. If a spouse tries to hide $500,000 by moving it through a series of digital wallets, the lawyer of 2026 uses specialized software to visualize the flow of funds. Statistically, the success rate of finding hidden crypto has jumped from 30% in 2020 to over 70% today, thanks to the maturation of blockchain tracking tools. This has eliminated the old-school strategy of hiding money under the mattress, as the digital mattress is now completely transparent to a high-powered legal algorithm. The economic reality of these technological advancements is a massive restructuring of the law firm business model. Historically, a divorce lawyer's revenue was tied directly to the billable hour. If a task took longer, the firm made more money. But as AI reduces the time required for tasks from 40 hours to 40 minutes, the billable hour is dying. Data from 2025 shows that 40% of mid-sized family law firms have shifted to a value-based pricing model or a flat-fee subscription for various stages of the divorce. For the consumer, the potential outcome is more predictable legal costs, but for the profession, it has led to a statistical culling of the workforce. Junior associate positions in family law have declined by 15% since 2022, as software now does the work that used to be the training ground for new attorneys. However, as we rely more on silicon, we encounter the problem of algorithmic bias. Historical trends in other areas of the law, like criminal sentencing, have shown that AI can inherit the prejudices of its programmers. In 2026, there are ongoing debates and case studies regarding the use of AI in calculating child support and alimony. Some jurisdictions have experimented with calculated fairness models where an algorithm suggests a settlement based on thousands of similar cases. But critics point out that these models often struggle with the outlier cases, the family with the special needs child or the spouse with a unique medical condition. The divorce lawyer's role is evolving into that of an auditor, someone who can argue against the machine when the statistical average fails to meet the individual need. Step by step, the lawyer is becoming a hybrid professional, part legal advocate, part data scientist, and part psychological counselor. The data shows that while the math of divorce is being solved by computers, the emotional volatility of the process is actually increasing. Historical data suggests that the faster a divorce moves, the less time the parties have to emotionally process the loss. This has created a new statistical demand for collaborative tech, where lawyers, financial neutrals, and mental health professionals all work within a single digital ecosystem to manage the dissolution of a marriage. As we look at the state of the industry in 2026, we see a profession that is more efficient, more transparent, and more data-driven than at any point in human history. We have solved the problem of hidden assets and judicial unpredictability, but this high-tech efficiency has revealed a new burgeoning trend that no one saw coming 20 years ago. As the millennials and Gen Z navigate this digital legal landscape, an entirely different demographic is breaking records for marital dissolution. In the next part of our deep dive, we are going to look at the silver divorce phenomenon. Why are couples who have been married for 30 or 40 years suddenly flooding the legal system? What does the data say about the unique financial challenges of dividing a lifetime of retirement savings and multi-generational property in an era of record-high longevity? The statistics of late-life divorce are staggering, and the legal strategies required to protect a 70-year-old future are entirely different from those used for a 30-year-old. You won't want to miss the deep dive into the most expensive and emotionally complex sector of the modern legal market. The shift towards silver divorce is perhaps the most significant statistical anomaly in the modern history of the American legal system. While divorce rates for younger generations have actually stabilized or even slightly declined over the last decade, the rate for adults over the age of 50 has more than doubled since the 1990s. For those over 65, the rate has nearly tripled. This is the Gray Divorce Revolution, and it has forced the U.S. divorce lawyer to abandon the playbook of the 1980s and 1990s in favor of a highly specialized understanding of geriatric economics and complex estate law. In the current year of 2026, a lawyer representing a client in their 60s is dealing with a set of variables that are fundamentally different from those of a young couple fighting over a nursery. Imagine if it is 2026 and you are a character named Linda. You are 62 years old and have been married to Thomas for 35 years. You raise 3 children who are now successful adults, and you are sitting on a combined net worth of $2.5 million, mostly tied up in a primary residence in Virginia, a 401k, and a vested corporate pension. In a traditional divorce scenario from 30 years ago, a couple in your position might have stayed together for the sake of the family legacy or due to social stigma. But historical trends show that the social cost of divorce has plummeted, while the medical and logistical reality of living another 30 years independently has become a statistical probability. For Linda's lawyer, the goal is no longer about child support. It is about ensuring that a fixed pool of assets can sustain 2 separate households for 3 decades of retirement. This demographic shift has turned the divorce lawyer into a specialist in the 10-year rule. This is a critical statistical threshold in the U.S. Social Security system. If a marriage lasts at least 10 years, a divorced spouse is entitled to claim benefits based on their ex-spouse's earnings record, provided they remain unmarried. In 2026, with the rising cost of living and the potential outcomes of a volatile social security landscape, the timing of a divorce filing is no longer just about emotional readiness. It is about actuarial precision. Lawyers often advise clients to wait until the 10-year and one-day mark to file, as this single day of marriage can be worth hundreds of thousands of dollars in lifetime benefits. This is a step-by-step tactical delay that has become a standard practice in the industry. Furthermore, we must look at the math of the Qualified Domestic Relations Order, or QDRO, in the context of a silver divorce. For a couple like Linda and Thomas, the 401k is not just a bank account, it is a tax-deferred engine. Dividing this asset in your 60s is a high-stakes surgical procedure. If the lawyer makes a mistake in the drafting of the QDRO, the potential outcome is a massive immediate tax hit and a 10% early withdrawal penalty if the client is under 59 and a half. In 2026, where every percentage point of a portfolio matters for long-term survival, divorce lawyers are now hiring specialized QDRO firms as consultants. Statistical data suggests that nearly 25% of all pension divisions in the early 2000s contained errors that led to litigation a decade later. Modern lawyers have responded by making the division of retirement assets the most documented and scrutinized part of the process. The house-rich, cash-poor dilemma is another area where the data is shifting. In the mid-20th century, the goal was often for the mother to keep the family home. In a silver divorce in 2026, keeping the home is often a statistical mistake. Consider a character named Robert, age 67. He wants to keep the 4-bedroom family home because of the memories. However, his lawyer presents him with a data-backed projection. Between property taxes, maintenance for an aging structure, and the lack of liquidity, keeping the home would leave Robert with only 15% of his net worth in liquid assets. Historical trends show that silver divorcees who sell the large family home and downsize into a high-efficiency condo or a managed community have a 40% higher rate of financial stability 5 years post-divorce. The lawyer's role has shifted from a defender of the home to a cold-eyed financial advisor who must convince their client to prioritize math over sentiment. We also have to address the health and long-term care factor. This is a variable that almost never appears in the divorce of a 30-year-old, but in 2026, it is a primary negotiation point. Who pays for the long-term care insurance premiums? If one spouse has a chronic condition, how does the division of assets account for the statistical likelihood of massive medical bills in the next decade? Case studies from 2024 and 2025 show a rise in what is known as a Medicaid divorce. This is a controversial legal strategy where a couple divorces specifically to protect the assets of the healthy spouse, while allowing the ill spouse to qualify for government-funded long-term care. While this is a risky and legally complex area, it highlights the desperate statistical measures families are taking as the cost of aging in America continues to rise. The emotional data of silver divorce is also unique. Unlike younger couples who may be fueled by the heat of an affair or a sudden conflict, older couples often report a slow, statistical drift known as the empty nest syndrome. Once the children leave, the lack of shared interests becomes a measurable distance. Historical data from the American Association of Retired Persons indicates that the primary reason for gray divorce is not high conflict abuse, but a desire for personal growth in the final third of life. This creates a different kind of legal environment, one that is often less about anger and more about a methodical business-like dissolution. However, the stakes remain high because there is no time to rebuild. A 40-year-old can lose half their wealth and have 25 years of earning potential to recover. A 65-year-old does not have that luxury. The divorce lawyer in this scenario is managing a zero-sum game where every dollar lost is a dollar that cannot be replaced. As we look at these older Americans navigating the legal system, we see the culmination of every legal trend we have discussed. The shift from fault to finance, the rise of expert-led negotiation, and the use of predictive analytics to secure a future. But as this demographic creates a new wave of legal work, they are doing so in an environment where their every move is being tracked. The silver divorcee of 2026 is just as likely to be active on social media as their children. This leads us to the next critical evolution of the profession. Whether you are 60 or 25, your digital footprint has become the most dangerous witness in the courtroom. In the next part of this deep dive, we are going to explore the terrifying statistical reality of the digital trail. How did a simple Facebook post or a LinkedIn update become the smoking gun in multi-million-dollar alimony disputes? We will examine the data on how lawyers use geolocation, metadata, and even smart home devices to catch spouses in lies. What happens when your own thermostat or your car's GPS becomes a witness for the opposition? You won't want to miss the shocking case studies on how the Internet of Things has turned the modern divorce into a digital forensic nightmare. We have officially entered the era of the digital dossier. In the mid-20th century, a divorce lawyer's greatest tool was a grainy photograph taken by a private investigator from the seat of a parked sedan. Today, in 2026, the sedan is a connected vehicle with its own GPS log, and the private investigator has been replaced by an e-discovery specialist who can reconstruct your life through a single cloud backup. The statistical shift here is absolute. According to historical trends tracked by the American Academy of Matrimonial Lawyers, over 80% of divorce attorneys have reported a massive surge in the use of social media and digital evidence in the last decade. But in 2026, we are moving beyond simple Facebook posts. We are entering the territory of the Internet of Things, where your own home has become a silent witness in your dissolution. Imagine if it is 2026 and you are a character named Marcus. Marcus is involved in a high-stakes alimony dispute. He claims that he is living a modest, solitary life in a small apartment to justify a lower support payment. However, his spouse's lawyer issues a subpoena not to Marcus's employer, but to his smart home provider. The step-by-step forensic deep dive begins. The lawyer pulls the logs from the smart thermostat and the smart lighting system. The data shows that the thermostat is consistently adjusted to 72 degrees at 6 p.m., and the smart fridge is being opened 40 times a day. More importantly, the logs from the smart lock show two distinct biometric signatures entering the home every evening. Statistically, this data creates a picture of cohabitation that Marcus cannot refute. This is the new reality of the U.S. divorce lawyer. They are no longer just arguing about what you say. They are analyzing what your devices know. Historical trends show that the first wave of digital evidence was purely social. In the early 2010s, it was the photo of a spouse at a party or a check-in at a luxury resort, while claiming financial hardship. But as we sit in 2026, the sophistication of this evidence has evolved into lifestyle analysis through metadata. Every photo you take contains EXIF data, a digital fingerprint that records the exact GPS coordinates, the time, and the device used. Case studies from 2024 and 2025 demonstrate how lawyers are using this to find hidden assets. Imagine a spouse who claims they have no interest in a particular vacation property, but they post a photo of a sunset. The lawyer's forensic team extracts the metadata and proves the photo was taken from the balcony of an undisclosed luxury condo in South Carolina. The potential outcome is a total collapse of that spouse's credibility in court, and a court-ordered appraisal of the hidden asset. The statistical weight of digital evidence has also fundamentally changed the way custody is litigated. Historically, custody was about testimony. Now it is about the digital trail of parenting. Lawyers are now using data from wearable devices like smartwatches to track a parent's activity. If a parent claims they are the primary caretaker but their Apple Watch or Fitbit shows they are at a gym or a bar 5 nights a week during their scheduled parenting time, that data is admissible. We are seeing a 45% increase in the use of wearable data in contested custody cases compared to just 5 years ago. Step by step, the lawyer builds a statistical model of a parent's presence or absence. They aren't just calling a neighbor to testify. They are presenting a heat map of the parent's location over a 6-month period. We must also look at the role of the connected car. In 2026, your car is essentially a smartphone on wheels. It tracks where you go, how fast you drive, and who you call via Bluetooth integration. Case studies have emerged where a spouse's car was used to prove a pattern of behavior that contradicted their testimony. For instance, if a spouse claims they were working late, but the car's infotainment system shows a recurring destination that happens to be a paramour's house, the lawyer has an airtight case. The divorce lawyer of 2026 has to be a technician. They must understand the difference between local storage and cloud syncing. They must know how to draft a subpoena that prevents the accidental deletion of data. The financial cost of this digital warfare is another area where the statistics are staggering. The price of a forensic data dump and analysis can range from $5,000 to $25,000 depending on the complexity of the digital ecosystem. For many middle-class families, this adds a layer of digital debt to an already expensive process. Historical data suggests that as the cost of discovery increases, the gap between the information-rich and the information-poor in the legal system widens. A spouse who cannot afford a forensic analyst may be at a statistical disadvantage compared to one who can. This has led to the rise of specialized digital advocacy groups that lobby for more transparent and affordable access to one's own data during legal proceedings. However, the most subtle and perhaps most dangerous digital trail is the one left on professional platforms like LinkedIn. In 2026, lawyers are using AI-driven scrapers to monitor the professional activity of opposing parties. Imagine a character named Chloe who claims she has been out of the workforce for so long that she is essentially unemployable, justifying a high alimony demand. But the opposing lawyer's software flags that Chloe has been active on LinkedIn, completing professional certifications in project management, and engaging with recruiters in high-paying sectors. The data shows she is open to work for roles with a median salary of $120,000. This statistical evidence of earning capacity can drastically alter the potential outcome of a spousal support award. The lawyer isn't just looking at what you have done, they are looking at what the market says you are worth. Even our pets have been brought into the digital courtroom. With the rise of smart collars and GPS-enabled pet trackers, lawyers are using animal movements to prove occupancy or neglect. If a dog's tracker shows it hasn't left a small crate for 12 hours while a parent was supposedly home and active with the children, it becomes a piece of the larger evidentiary puzzle. Every device in the modern home is a potential witness. This level of surveillance has led to a new phenomenon in the legal profession: the digital sweep consultation. Before a divorce is even filed, lawyers in 2026 are increasingly advising clients to conduct a thorough audit of their digital footprint, changing passwords, and disabling shared cloud accounts. This isn't about hiding evidence, which is illegal, but about protecting privacy in an age where everything is recorded. As we analyze this history, we see that the U.S. divorce lawyer has transitioned from a storyteller to a data scientist. They are no longer just painting a picture of a marriage for a judge. They are presenting a spreadsheet of digital interactions. This reliance on data has made the process more objective in some ways, but far more invasive in others. The statistical probability of a secret remaining a secret in a 2026 divorce is nearly zero. If the data exists, a modern lawyer will find the path to it. But even with all this high-tech surveillance, there is one document that can override almost every digital discovery we have discussed. It is the ultimate shield in the world of matrimonial law, the contract. While AI and IoT are changing how we find the truth, the legal truth is still often dictated by a piece of paper signed years before the marriage even began. In the next part of this masterclass, we are going to look at the explosive rise of the prenuptial and postnuptial agreement. We will examine the data on why Generation Z is obsessed with these contracts and how a single clause can render a $1 million forensic investigation completely irrelevant. Why are people who are madly in love spending $10,000 on a contract before they say, "I do"? The statistics on the death of the romantic marriage and the rise of the business marriage will change everything you think you know about modern love. The transition from the romantic marriage to the contractual marriage is perhaps the most quantifiable shift in the history of the American legal system. For most of the 20th century, the prenuptial agreement was a tool reserved exclusively for the top 1% of earners, the titans of industry or old money dynasties seeking to shield family trusts. However, as we look at the data in 2026, the prenuptial agreement has become a standard requirement for the American middle class, specifically driven by the pragmatism of Generation Z and millennials. Statistical data from the American Academy of Matrimonial Lawyers indicates a 62% increase in the number of attorneys who have seen a rise in prenuptial agreements over the last 3 years. This is not just a trend. It is a fundamental restructuring of how Americans enter the institution of marriage. Imagine if it is 2026 and you are a character named Jordan. You are 28 years old, working in a specialized field like biomedical engineering, and you have approximately $80,000 in student loan debt, but you also have a vested interest in a small startup and a growing portfolio of digital assets. You are planning to marry Taylor, who is a freelance graphic designer with minimal debt, but high future earning potential. In the 1990s, the idea of a prenup for Jordan and Taylor would have been seen as an act of bad faith or a lack of trust. In 2026, Jordan and Taylor see it as a financial planning document. For their lawyer, the task is to create a step-by-step partition of premarital debt and future intellectual property. The historical trends show that younger generations, having witnessed the high-stakes divorces of their parents or the economic volatility of the 2010s, view the contract as a way to avoid the very legal machinery we have discussed in the previous parts of this series. The rise of the prenuptial agreement has changed the divorce lawyer's job from a litigator of the past to an architect of the future. The step-by-step process of drafting a modern prenup is rigorous. It begins with full financial disclosure. Historically, many prenups were overturned because one party hid a bank account or an inheritance. In 2026, lawyers use the same AI-driven forensic tools we discussed in Part 5 to verify that both parties are being 100% transparent. If the data shows a discrepancy of even a few $1,000s, the entire contract could be deemed unconscionable later. The lawyer must also ensure that both parties have independent legal counsel. This is a critical statistical safeguard. Historical case studies show that if one lawyer drafts a prenup for both parties, the document has a nearly 70% higher chance of being invalidated in court under the theory of duress or conflict of interest. We must also look at the evolution of the clauses themselves. In the 1980s, a prenup was a simple document. I keep my house, you keep yours. In 2026, we are seeing the rise of the lifestyle clause and the social media clause. These are fascinating historical developments. A social media clause might specify that in the event of a separation, neither party can post disparaging content about the other to a following of a certain size, or it might dictate the ownership of a shared YouTube channel or Instagram brand. Statistical analysis shows that for digital creators, the value of their online persona often exceeds their physical assets. Lawyers are now tasked with putting a dollar value on a handle or a subscriber base. Another major shift is the inclusion of infidelity clauses. While many states, such as California, often view these as unenforceable due to no-fault divorce laws, lawyers in other jurisdictions continue to draft them as a deterrent. Historical trends suggest that while these clauses might not always hold up in court, they serve as a powerful psychological and negotiation tool during a settlement. The divorce lawyer has to explain the potential outcomes of these clauses, showing the client that while they might not get a specific payout for a spouse's bad behavior, the clause can be used to leverage a more favorable division of other tangible assets. Then there is the rise of the postnuptial agreement. This is a document signed after the wedding, often triggered by a significant change in financial circumstances. Imagine if it is 2026 and a character named Sarah, who has been married for 8 years, suddenly receives a $500,000 inheritance or sees her small business go through a massive series of funding round. Historical data indicates a surge in postnups during midlife career pivots. The lawyer's role here is to ring-fence this new wealth. Without a postnup, that inheritance could easily become commingled with marital funds, for example, if Sarah uses it to pay down the mortgage on the family home. Once funds are commingled, they are statistically likely to be split 50-50 in a divorce. The postnup acts as a legal firewall, preserving the separate nature of the asset. The economic impact of the prenup culture is profound. It essentially privatizes the divorce law. By deciding the potential outcomes of a split in advance, couples are effectively opting out of the multi-year, high-cost litigation process. However, this has created a new niche for the divorce lawyer, the prenup challenger. As more people enter marriages with contracts, more people leave them trying to break those contracts. The legal battles of 2026 are increasingly focused on the circumstances under which the prenup was signed. Was it signed 2 hours before the wedding? That's evidence of duress. Was the language too complex for a non-native speaker to understand? That's a violation of procedural fairness. The statistics show that while prenups reduce the number of contested property trials, they increase the number of preliminary hearings regarding the validity of the contract itself. We also have to consider the sunset clause. This is a historical mechanism that is seeing a resurgence in 2026. A sunset clause states that the prenup expires after a certain number of years, say 15 or 20. The data suggests that this is a compromise for couples who feel that a permanent prenup is too cold. It says, if we survive the statistically volatile first decade of marriage, we will revert to the standard laws of the state. This shows how the legal profession is adapting to the human desire for both security and romantic evolution. The shift toward a contractual marriage model has led to the birth of the business marriage. In this model, the emotional relationship is separate from the economic partnership. This is a return to a much older historical way of viewing marriage, but with a modern individualistic twist. The U.S. divorce lawyer of 2026 is no longer just a person you call when things go wrong. They are a consultant you hire to ensure that things can end cleanly. This has led to a fascinating statistical reality. Couples with prenups often report less anxiety about money during the marriage, even if the existence of the contract acknowledges the statistical possibility of an end. As we look at the state of matrimonial law in 2026, We see a system that has moved from moral judgment to financial management. We have used AI to find the money, IoT to track the behavior, and contracts to dictate the outcome. We have professionalized every aspect of the American heartbreak. But as the American legal system becomes more efficient and contractual, it has also become more isolated. But what happens when the marriage isn't just between two Americans? What happens when the assets are in London, the husband is in Dubai, and the wife is in New York? In the next part of this deep dive, we are going to explore the high-stakes world of international divorce and jurisdictional warfare. We will look at the data behind why London is known as the divorce capital of the world, and how wealthy individuals engage in forum shopping to find the most favorable laws. What happens when two different countries claim authority over a single family? You won't want to miss the shocking statistics on the cost of global legal battles and the secret strategies used to win the jurisdictional race to the courthouse. The jurisdictional race to the courthouse is the ultimate high-stakes gamble in the world of international family law. In the mid-20th century, a divorce was largely a local affair, governed by the statutes of the county where the couple resided. But as we sit here in 2026, the globalization of wealth and the mobility of the American workforce have turned the U.S. divorce lawyer into a cross-border strategist. Statistically, the number of marriages in the United States involving at least one foreign national or significant offshore assets has increased by nearly 40% over the last 2 decades. This has created a legal phenomenon known as forum shopping, where the potential outcome of a case is determined not by the facts of the marriage, but by which country's flag is flying over the courthouse. Imagine if it is 2026 and you are a character named Elena. You are an American citizen living in New York, but your spouse is a tech executive from the United Kingdom. Together, you own a penthouse in Manhattan, a villa in the south of France, and several $1 million held in a trust in the Cayman Islands. In this scenario, the first person to file the paperwork effectively chooses the legal rules for the entire dissolution. This is the concept of lease alibi pendens. The rule that the court first seized of the matter is the one that proceeds. For Elena's lawyer, the next 24 hours are a statistical sprint. If the spouse files in London first, the historical trends suggest a much more favorable outcome for the financially weaker party, as English courts are known for their generous sharing principle, which often results in a 50-50 split of all assets, regardless of when they were acquired. However, if Elena files in New York first, the court will apply the doctrine of equitable distribution, which may exclude certain premarital assets or inherited wealth. The data behind London being the divorce capital of the world is staggering. Historical data from the last decade shows that wealthy spouses, often referred to as the breadwinners, will spend hundreds of thousands of dollars in legal fees just to avoid a London filing. Conversely, the non-earning spouse will do everything in their power to establish jurisdiction there. In 2026, the divorce lawyer has to be an expert in the habitual residence test. This is a step-by-step analysis of where a person truly lives. It involves tracking credit card transactions, school drop-off logs, and even the frequency of doctor visits to prove that a client has sufficient ties to a specific country. A single month of residence can be the difference between a $10 million settlement and a $2 million settlement. But the complexity doesn't stop at the division of bank accounts. We must look at the statistical nightmare of international child custody and the Hague Convention on the civil aspects of international child abduction. This is one of the most intense areas of the legal profession. Historical trends show that as global mobility increases, so do cases of one parent taking a child to a foreign country without consent. In 2026, the U.S. divorce lawyer handles approximately 1,000 outgoing Hague cases per year. The data indicates that the success rate of returning a child depends heavily on the destination country. For instance, returning a child from a signatory country like Germany has a statistical success rate of over 70%, whereas cases involving non-signatory nations can languish for years with a less than 10% probability of recovery. Step by step, the lawyer must navigate the central authority of each nation. They have to prove that the child was a habitual resident of the U.S., and that the removal was a breach of custody rights. This is where the digital forensic tools we discussed in Part 7 become life-saving. Lawyers use GPS data from the child's tablet or the parent's social media check-ins to locate the child in real time. In 2026, the speed of digital discovery has reduced the average time to locate a child from weeks to mere hours, but the legal battle to bring them home remains a multi-year marathon. Furthermore, we must address the enforcement gap. Imagine a character named David who wins a $3 million judgment in a California court against a spouse who has moved all their assets to a non-extradition jurisdiction, or a country that does not recognize U.S. civil judgments. Statistically, nearly 30% of high-net-worth international judgments go partially or fully unpaid because of the difficulty of cross-border enforcement. The modern lawyer of 2026 uses a strategy called asset freezing orders or mar-eva injunctions. This is a worldwide order that prevents a spouse from moving assets while the case is pending. To get this, the lawyer must present a statistical risk profile to the judge, showing that the spouse has the means and the historical tendency to hide funds. The economic impact of these global battles has led to the rise of the international legal network. In the 1990s, a divorce lawyer was a solo practitioner. In 2026, the top family law firms are multinational corporations with offices in Dubai, Singapore, and Zurich. This professionalization has driven the average cost of an international divorce into the stratosphere. Case studies from 2024 show that the legal and forensic accounting fees for a contested multi-jurisdictional divorce can easily exceed $2 million. This creates a statistical barrier to entry. International justice is often a luxury available only to the global elite. We also see a rising trend in the use of Islamic family law or Sharia principles in cases involving residents of the Middle East. The U.S. divorce lawyer in 2026 must understand the interaction between a civil judgment in Michigan and a mar, the dowry agreement, in a religious contract. Historical trends show that U.S. courts are increasingly willing to enforce the financial aspects of these contracts, provided they don't violate public policy. This requires a step-by-step theological and legal analysis that was completely absent from the American legal curriculum 40 years ago. As the data shows, the divorce lawyer is no longer just an advocate. They are a geopolitical chess player. They are managing the tension between different cultures, different currencies, and different definitions of fairness. The statistical probability of a simple one-country divorce is shrinking every year. We are living in an era where the law is as mobile as the people it governs. We have explored the history of the profession from the local courthouse to the global stage. We have seen how technology, contracts, and international treaties have reshaped the American family. But as we reach the conclusion of this masterclass, we have to look toward the horizon. The legal system is on the verge of a total paradigm shift. As we enter the final part of this series, we are going to look at the 2030 projections. Is the divorce lawyer an endangered species? We will examine the data on the rise of self-governing smart contracts that trigger a divorce automatically based on data inputs. What happens to the profession when the law is no longer a human argument but a line of code? You won't want to miss the final shocking look at the future of the great American breakup. The horizon of 2030 presents a statistical reality that would have been indistinguishable from science fiction to the practitioners of the 1950s. We are moving toward the era of the self-executing marriage, where the U.S. divorce lawyer is transitioning from a storyteller to a systems architect. As we look at the historical trends, we see that the friction in the legal system, the delays, the costs, and the human errors, was often the only thing slowing down the dissolution of the American family. But as that friction is removed by the algorithm, the data suggests a radical shift in how we value commitment and how we calculate the potential outcomes of a split. Imagine if it is 2030 and you are a character named Sophia. You and your spouse, Jax, entered into a smart contract marriage license 4 years ago. This license is not a piece of paper in a county clerk's office. It is a decentralized autonomous organization, or a DAO, on a blockchain. The contract contains pre-negotiated terms for every possible variable we have discussed in this masterclass. It has a real-time feed from your joint bank accounts, your brokerage portfolios, and the Zillow API for your primary residence. In 2030, when Sophia decides the marriage is over, she doesn't call a lawyer to file a petition. She initiates a digital trigger within the contract. The step-by-step execution of this divorce happens in milliseconds. The smart contract, acting as a digital mediator, automatically reroutes the title of the home based on the pre-agreed equity split. It triggers a transfer of cryptocurrency and stock shares. It even communicates with a parenting app to lock in the 50-50 custody schedule, based on the children's school enrollment data. In this scenario, the historical trend of the 2-year legal battle is compressed into a single block on the chain. The divorce lawyer's role in this future is not to litigate the split, but to have been the one who audited the code before the wedding. Statistically, the impact on the legal profession is profound. Data from early 2026 suggests that while the volume of marriages remains lower than the 20th century peak, the complexity of these contracts is rising. We are seeing a decline in the traditional litigation-based firm and a massive surge in the legal tech consultancy. The potential outcome is a world where the average American spends more on the front-end creation of their marital contract than on the back-end dissolution. This is a complete reversal of the 1980s model where the entry was free and the exit was financially ruinous. However, we must examine the data regarding the human element. Historical trends indicate that as divorce becomes more frictionless, the rate of relitigation actually increases. When a computer splits a bank account, it doesn't account for the emotional closure that a human judge or mediator provides. Case studies from 2025 highlight a phenomenon called the algorithm remorse. Couples who utilized automated splits often return to human lawyers 18 months later, claiming that the data used by the Oracle, the external data source feeding the smart contract, was flawed or that the circumstances of their lives changed in ways the code could not predict. This brings us to the rise of the ethics consultant within family law. In 2026, top-tier law firms are no longer just hiring JD holders. They are hiring data ethicists and behavioral psychologists. Their job is to ensure that the predictive analytics used to set child support do not become a tool of systemic bias. For example, if an algorithm predicts a father will be 20% less involved based on his work travel history, the ethics consultant must intervene to present the human context that the data misses. Step by step, the profession is evolving to protect the outliers, the families that do not fit the statistical mean. We also have to look at the statistical shift in how legal services are paid for. The billable hour, which has been the heartbeat of the profession since the 1960s, is nearing its final days. In its place, we see the rise of the subscription legal model. Imagine a character named Leo in 2026, who pays a monthly fee to a legal tech firm. This subscription provides him with ongoing protection. An AI that monitors his assets, updates his prenuptial agreement automatically as his career progresses, and provides immediate mediation services if a conflict arises. This model turns the lawyer from a reactive crisis manager into a proactive risk mitigator. The data suggests that this proactive model could stabilize the American divorce rate. When the potential outcomes of a split are visible in real time on a dashboard, couples are more likely to engage in counseling or mediation before the point of no return. Historical data shows that financial uncertainty is one of the top 3 drivers of marital stress. By removing that uncertainty through transparent, algorithmic contracts, the legal profession might inadvertently be saving more marriages than it ends. But what about the children? In our deep dive, we have seen the shift from the tender years doctrine to the 50-50 presumption. In 2030, the data points toward the rise of the digital guardian. This is a neutral AI monitor that analyzes the communication between co-parents and provides real-time feedback. If a text message from one parent to another contains high-conflict language or violates the preset boundaries of the parenting plan, the AI flags it. Statistically, the use of these digital guardians has led to a 30% reduction in post-divorce litigation over parenting time. The divorce lawyer of the future is the one who designs the parameters of these digital guardians, ensuring they remain focused on the best interests of the child. As we conclude this 10-part masterclass, we must look at the macro-statistical landscape. Since the 1950s, the U.S. divorce lawyer has moved through 4 distinct eras: the era of fault, 1950 to 1970, the era of finance, 1970 to 1990, the era of discovery, 1990 to 2010, and the era of data, 2010 to 2026. Each era was defined by a specific tool: the private investigator, the forensic accountant, the email trail, and finally the algorithm. The profession has proven to be remarkably resilient, adapting to every technological and social shift with a new way to bill for expertise. The historical trends are clear. As long as Americans continue to value individual happiness and the right to self-determination, the machinery of divorce will continue to grow. It is a multi-billion-dollar industry that mirrors our deepest anxieties and our highest hopes for the future. Whether the lawyer is a human in a suit or a line of code in a cloud, the goal remains the same: to navigate the messy transition from one life to the next while protecting the assets and the children caught in the middle. In 2026, we stand at the precipice of the most significant change in legal history. The Great American Breakup is no longer a localized event. It is a global, digital, and contractual phenomenon. By understanding these statistics, you are not just looking at the past. You are preparing for a future where the law is faster, more invasive, and more precise than ever before. This has been a statistical look at the history of the U.S. divorce lawyer. And while the technology changes, the human story of love, loss, and the struggle for fairness remains eternal. But there is one final piece of the puzzle that we haven't touched on. As we look at the rise of the algorithmic lawyer, a new question emerges. If the computer can handle the divorce, can it also handle the marriage? We are seeing the first statistical ripples of the AI-matched union, where data is used to predict marital success before the first date. What happens when the same machine that ends your marriage is the one that started it? In our next deep dive series, we will explore the terrifying data behind the algorithmic romance and the future of the American wedding. You won't want to miss the shocking truth about how data is replacing destiny in the pursuit of love.